Filing your petition only opens the door to your California case. Your spouse still has to be formally notified, and the court needs proof it happened correctly. That's what this video covers: who's allowed to serve the papers, the methods California recognizes, and the forms that prove it happened. Start with who's allowed to do the serving. The person who delivers the summons and petition has to be at least 18 years old and cannot be a party to the case. That second rule surprises a lot of people. The petitioner can never serve their own papers, no matter how cooperative or straightforward the situation is. The court needs an independent, neutral confirmation that service actually happened, and a party to the case can't provide that. Eligible servers commonly include a friend, an adult family member who isn't part of the case, a coworker, or a professional process server. What actually has to be delivered is more than just the petition itself. The respondent generally needs copies of the summons, Form FL-110, the petition, Form FL-100, a blank response form, FL-120, so they have what they need to reply, a UCCJEA declaration if you have minor children together, and anything else filed alongside the petition like a fee waiver request. California recognizes a few valid methods of service. Personal service, where an eligible adult hands the documents directly to the respondent, is the most straightforward and most common. Substituted service comes into play after reasonable attempts at personal service haven't worked. The documents are left with another responsible adult at the respondent's home or workplace, and then also mailed to the respondent, with specific follow-up steps required. And service by mail with a notice and acknowledgement of receipt, Form FL-117, is available when both spouses are cooperative and the respondent is willing to sign and return that acknowledgement. Whichever method is used, the person who did the serving completes and signs Form FL-115, Proof of Service of Summons. This is a sworn statement, not something the petitioner fills out, that tells the court who was served, what documents were delivered, and exactly when, where, and how. Section by section, FL-115 covers the case information at the top, who was served, and, for substituted service, who the responsible adult was, what documents were delivered matched against what was actually filed with the court, and the date, time, and place of service. That date, time, and place section matters more than it looks. It's the date that starts California's mandatory 6-month waiting period, so it needs to be accurate. The form closes with the method of service used and the server's signature, made under penalty of perjury. Filing the proof of service is not optional once it's signed. Until FL-115 is on file with the court, there's no verified record that the respondent was notified, the 30-day response window hasn't formally started, and the 6-month waiting period hasn't begun either. FL-115 covers the initial petition and summons specifically. Once your case is underway, plenty of later documents, routine declarations, disclosures, and responses to certain motions can generally be served by regular mail instead, and that's where Form FL-335, Proof of Service by Mail, comes in. It's completed by the adult who did the mailing, who, again, can't be a party to the case, and it documents what was mailed, who it went to, and the date and location of the mailing. The same core rule applies to both forms. Whoever serves or mails the documents signs the proof, and a party can never do that for their own paperwork. And a signed proof that never gets filed doesn't help your case at all. The court only has evidence that service happened once the completed form is actually filed with the clerk. Most service problems trace back to small details rather than complicated law: an inexact service date, the wrong method for the situation, or a proof of service that's filled out but never actually filed. Virdix's guided questions help keep the details on your proof of service consistent with what you actually filed and served, so that piece of your case doesn't stall the rest of it. Virdix is a document preparation service, not a law firm, so this is not legal advice. And for advice about your specific situation, talk to a licensed attorney. You can start at virdix.co.